Welcome, everybody, to the Baylor Law Executive LLM and Litigation Management monthly webinar. We're privileged today to have joining us for what should be an interesting discussion. The title of the webinar is Should I Stay or Should I Go? Data Analytics and Forum Selection Issues. And we're obviously privileged to have a great panel with us to talk about these issues based upon some research that's been done and sort of how it impacts us. That panel includes Rich Finkelman, Carl Schleep, Dan Eveson, and Andrew Stultz. You know, when we talk about the issue, I want to put it into perspective given what we do at Baylor. And one of the things that we talk about is setting the pace of litigation. And the pace of litigation is how you progress through that litigation. What's the pace with which you want to proceed through that litigation, whether you're the plaintiff or whether you're the defense? Because pace affects the scope of a project, it affects the planning of the project, it affects the execution of it. But there are external factors that can influence or have an impact upon that pace that you would like to use or proceed through handling that particular litigation. And one of those external influences is the court system itself. And so what we're going to talk about, based upon some data that BRG and Gavalytics and others have put together, is what is the impact of the pandemic on proceeding through a case, progressing through a case. So I'm going to turn it over to Rich, and I'm going to let you lead this sort of discussion. And I, from time to time, will ask some questions that may be helpful in understanding the topics. Thank you all for being here, and we look forward to this discussion that we're going to have. Rich, turn it over to you.
Thanks, Kyle. I'm going to share a presentation here that we put together. It'll take a minute just to go through some introductions and then talk about the work that we did in analyzing the impact COVID's had on future trial dates. And then hopefully we'll have some kind of roundtable discussion about questions that you guys have in the audience. I'll start with introducing BRG. We're a worldwide consulting firm. We have over 1,200 consultants, and we do everything from expert witness work to advisory consulting. And we have an artificial intelligence and machine learning practice. I'm a managing director in that practice, and Carl Schleep, who's with me on this project and on this call, is a senior managing consultant in our practice. I'll give you a couple quick examples of the kind of work that we do in the artificial intelligence arena. In disputes, we do a lot of work with prediction, and prediction can be anything from predicting privileged documents without keywords to similarity scoring and looking at things like the credibility of witness testimony over periods of time. We do some compliance work as well, because prediction is really good at finding anomalies, and we're pretty expert at doing that. And then we've done some interesting work in financial services where we've analyzed the language of regulatory filings to find volatility in periods of what people are saying about things like management's discussion of risk or ESG issues. So those are just a handful of examples, and I'm going to quickly let the other panelists introduce themselves, and then we'll get into the heart of what we did in our project. Dan, you want to go?
Hi. Thank you very much, Rich. So I'm the Chief Product Officer at Gavalytics. And what we do, I suppose, is kind of a single use of very similar technology that Rich relies on for a lot of the work that BRG does. So we are basically a natural language processing and artificial intelligence company, but we focus purely on state court data. So state court data in itself, it's a very disordered world, but there are millions upon millions of records out there. And at the end of the day, at this point, it's become a bit of a commodity within the industry. All of us have millions upon millions of these things. What the actual value add that you provide is reading them. A human can never read 30 million records, but a computer can. And if you can get the accuracy on that, you can produce very large data sets for which you can generate real conclusions and find anomalous data points. Does this judge happen to do something grant every single motion for summary judgment in front of them outside of, statistical significance. So just trying to look for those little things which don't make sense or even do make sense based on kind of what's going on in the outside world. We basically started out in California, and now we cover pretty much most of the population centers in the US. I think that's everything. Thanks, Rich.
Great. Andrew?
Thanks, Rich. I am Andrew Stoltz. I'm Vice President with Wallingford Capital. Wallingford Capital is a commercial litigation funder, and as the slide indicates, we're relatively large. We have over $1.2 billion in capital under management. We put that money to work investing in cases, mostly in the plaintiff side of cases. And we focus on sort of 3 to 4 subject matter areas. Commercial cases broadly defined, any type of case that has a commercial aspect to it, anything from breach of contract, fraud, business towards those sorts of things. Antitrust and trade cases, international arbitrations, which I tend to bucket with commercial, but it is its own beast in a certain sense. And then intellectual property, including patent cases. The reason that those are the cases that we focus on is because the attorney team, practiced, litigated, and tried cases in those areas throughout our careers, and everybody has at least a decade, and everyone has more experience in those, some combination of those subject matter areas. As I said, we invest mostly in the plaintiff side of cases. The structuring of how we invest is tailored to each case, but some of the basics are funding attorneys' fees and expenses along the way for litigants. We also focus on monetization, straight claim monetizations is what we call it. The only other thing I'll mention at this point is that we're a passive non-recourse investor. So being able to diligence our cases, and I'm sure that we'll get into it more as the panel progresses, including looking at timing, which is what we're going to be talking about today, among other things. Timing, venue, those types of things it is very important to us. And of course, we're a non-recourse investor. As I said, we only recover if our counterparty, the plaintiffs in the cases, recovers as well. So, Rich, with that, I'll flip it back to you, and thanks for having me.
Hey, Rich, I was going to let me interject one thing, and that is we have a chat feature. And if you have any questions as we progress through this and the discussion continues, go ahead and put them in the chat feature. And we can open it up at the end of the discussion for questions as well. But I'll be monitoring that and seeing what kinds of questions that we might have and can address. So go ahead, Rich. Thanks.
Great, thanks. We asked ourselves last year what impact COVID was going to have on future trial dates. And it was a discussion we started internally. We decided to do our own work. Nobody asked us to do this. Turned out that it was a pretty good idea in terms of, taking a look at what impact COVID has had. And Dan mentioned, state court data is a mismatch of different formats. The federal court system publishes data regularly, and it's not a mismatch, it's uniform. So we started there. And what we looked at was a period of time for 4 years prior to 2020. And in the court systems, the way that they track cases is by when they're filed, they count filings, and then they break them down by types, but then they also tell you when cases are terminated. And they give you the statistics, and termination is, a dismissal, a settlement, a trial, verdict. And along the spectrum, they'll give you stats by circuit, by type of case, a whole bunch of information. So what we did was we took a look at 4 years of this data and then used it to predict what 2020 would have looked like without COVID. And then we bumped up what the numbers were. I'll take a breath and say that we're waiting for 2021 data, which should be out, in the next 30 days or so, and we're going to update this. but we did this work like 6 months ago, and we found some really interesting data points. When we got done with the federal stuff, we reached out to Gavalytics, who we met through Baylor. So thank you, Kyle. We were working with your class on a project, and you had Gavalytics. That's how we met them. And they gave us some state court data so that we could see if our analytics, how they work there. And some similar findings came out of that. So I'm going to switch and let Carl walk us through some of the data and what we found out, and then we'll have a group conversation about what it all means. And Carl, I'm gonna well, let me do this slide and then I'll hand it over to you. What we found was that on average, cases are going to get pushed out 13 months across all circuits. We also found that we expect a 47% increase in trials over the next few years, primarily because the biggest backlog in cases is in pretrial. Most of us who are in the industry know that when COVID happened, discovery stopped essentially because no one knew. Trials shut down, the courts, spent a few months trying to figure stuff out. And even now that they're moving forward, it took a while for the activity in pretrial to pick back up again. And the sheer backlog to us, our analytics showed that, to work it out, there's still going to be cases that go to trial, and it's going to be higher. And this was before Omicron, so we'll bump that in as we move forward. Our results were published in Law 360. We have an interactive court map that you can go into. It's a Tableau website. It's here, and we can show it to you, and you can surf around and see, different circuits, different years, and what the predictions are. And with that, I'm going to turn it over to you, Carl. You want to talk about the map for a second, and then we can go into the work.
Sure, yeah. So our interactive map on the Tableau website is kind of just a utility for anyone to look into the data for themselves. We can't talk about all the different findings that you might, see in there, but having the interactive map, you can go to it, you can look through your specific circuit that you care about, you can pull the data, all the data is publicly accessible from that, and you can draw your own, extrapolations and conclusions to learn more about anything that you really want to of the data that we've got. So in the Tableau website, there's a bunch of options where you can look at data back through 2017, broken down into the total number of civil cases, US civil cases, or private civil cases, and then also where along the line are those cases in the court system? Are they pre-trial? Are they before any other court action? Are they where are they along in those steps? And it's broken down all by districts, so you can investigate it that way. And I think with that, you can go to.
So let me jump in. When I mentioned that there were 13 months delay, that's across all circuits when we averaged them out. What we found was there were outliers, and the two we're about to talk about are the Fourth Circuit and the Fifth Circuit. In the Fourth Circuit, it's actually pushed out to something like 2 years. There were way more filings than predicted, and there were way fewer terminations and settlements than predicted. The Fifth Circuit, just the opposite happened. There were a lot fewer filings, and there was a lot more terminations and settlements than was predicted. And so we're going to walk you through those two in the next two slides and show you some of the data that we found.
Yeah, so as Rich mentioned, first we're going to talk about maybe a bit of the methods that we use. So we had data from 2016, 2017, 2018, 2019. We fit that to a line and just extrapolated it. What would we be expecting 2020 to look like had COVID not happened? In the Fourth Circuit, what we see is it was pretty, it was actually higher. These are the number of cases filed. So the Fourth Circuit actually had more cases filed, significantly more cases filed than what we would have expected. And if you go to the next slide, we can see how that compares to the Fifth Circuit. So in the Fifth Circuit here, I'm plotting 3 different lines. These are the number of filings, the number of pending, and then the terminated cases. And what I've got plotted here is the dotted line is our extrapolated fit. So this is what we would have expected to happen. And the X dots are actually what happened. So you can see that the pending, the blue line at the top, the pending was expected to go up, meaning in the years prior, their backlog was steadily increasing. What happened in the Fifth Circuit is they actually, they went through, they crushed through a significant portion of their backlog and actually turned a corner on that. And similar things can be shown in the number of terminations. They drastically increased the number of terminations, but with that, the number of filings was actually down. So the takeaway from this is, in the Fifth Circuit, there were fewer filings, so the court systems were able to get through a large portion of their backlog, which is counterintuitive of what you might think with what's happening with COVID, that the court system shut down and fewer filings. But what we see here is that the court system kept on moving. It kept on at a similar pace or faster, and got through a large section of its backlog due to reduced number of filings due to COVID.
And our prediction is you're going to go to trial sooner in the Fifth Circuit than you would have prior to COVID, that your trial date, you should expect it to get moved up. I will add parenthetically that this is at a circuit level in certain areas, and when we get into the state stuff, it'll be more obvious. The backlog of criminal cases has a direct impact on some of these analytics. For sure, in the circuit court in DC, they've got a backlog of criminal cases from a year ago, from January 6th, and those cases are going to be delayed beyond what our model predicts, and we can't exactly pinpoint it, but we know that's a fact because criminal cases are taking precedence over civil cases. So, Carl, you want to talk about this trend line and how we came up with this?
Sure, yeah. So we did the same approach as before. We're basically butting up against what we predicted to happen to what actually happened. And now we're measuring the duration in months that the average number of cases are for each one of these. So the average duration of case for a case in the no court action stayed about the same, 5 months. For what actually happened and what it predicted. The real difference that we see here is in the during or after pretrial phase of the court. The average duration was, something like, what is that? 12, 13 months longer than what was predicted. Basically meaning during all of COVID, every case that was in the during or after pretrial is stuck there. During that whole year, basically none of the cases from there shifted around, meaning the court systems basically stalled out at that point.
And that's the 13 months. That's where the average 13 months. And we know that anecdotally because we're all in the business, right? And so we all know what happened when COVID happened and the way everything shut down and getting, back up and doing stuff. And Carl's right. The stuff that was already in pretrial stopped, and then cases that were moving towards pretrial, those don't involve getting a jury together or doing much. So, they got added onto that. So I'm going to jump now and let Dan talk a little bit about the Gavalytics. We found, so they gave us data from 4 California jurisdictions and Texas and New York. And I want to jump in here and talk about what we found in state courts.
So when it comes to state courts, because it's a bit of a Wild West and not just California in terms of accessing it, there's also a lot more variations in terms of the size of each of these places. Like Los Angeles County has as many, it's got 10 million people in it. You compare it to Alameda, where the population is very small. It's actually a very disparate kind of world that you're in. So we threw over to BRG all of the data which we have, so we can analyze from disparate sources how long each of these cases are going. And we can try our best to line up with the same kind of fields which federal were relying on. So taking those kind of data together, I believe we saw effectively the same trends that one would see in federal, but the kind of dichotomy that, as far as I'm aware, was on the size of the county. Is that correct, Rich?
Yeah, the size of the county, and then big cities skewed it because of criminal cases. That was the big one for us. I know, in Los Angeles County, California suspended the right to a speedy trial, and now they have a backlog of criminal cases. They've cross-trained the judges on handling criminal matters. And if you're going to file a civil case in Los Angeles County, you're waiting a long time to actually get in front of a jury. So that was some of the findings. So they're matched up. I think what the data you provided us gave us more insight into the tension between criminal and civil, right? Because the federal court system doesn't deal with as many criminal matters as the state court systems do. So, but all this rolled together is part of predicting, where do you file? What do you do if you're already in a venue? What do you do? Do you stay? If it's predicted that your trial is getting pushed out, do you go get litigation funding? If it's predicted that your trial is going to come faster, how do you deal with that? So, I think what we found out was that there are so many variables here that the one thing we can tell you is it's changed. Now, there are some locations where things did not change, some of the smaller counties here, and then some of the circuit courts turned out, to not shift that much. But in general, I think everybody should expect that their trial dates are going to get pushed out.
And there are some strategic kind of points on that. Like, if you know that your trial date is going to be very far out and the other side is not particularly liquid with their own litigation funding, it puts you in a far stronger position for things like settling, which, should be the aim of the court system.
Yeah, and before I jump to the next slide, I'll ask Andrew to jump in and give us his thoughts on this data.
Yeah, I think that's right, Dan. I think as a litigant, it fully depends on what your strategy is. Right. If you are, for example, as you said, a plaintiff, and you're looking at a couple of venues, right? You maybe have venue in one or two spots. This data could be really useful in determining, hey, I want to get to trial as quickly as possible, versus relying on the budget that would have been correct 2 or 3 years ago, in a specific venue that maybe now the case is going to get stretched out 12, 18, 24 months longer than we thought, and it's going to be more expensive than it would have been a couple of years ago, which obviously is where someone like us could come in. So yeah, it's very useful, I think, for the litigants, to be able to refer to this data. The why, right, is always going to be the question, and I'll let Rich comment on that. Everybody will sort of have their hypotheses about why one venue versus another may be experiencing some of this stuff, as you said, the criminal backlogs and speedy trial acts. Those sort of things.
Well, yeah, that's right. And we also found there was a part of the North Florida that had, a big outlier in terms of a bunch of case filings, and I think that was a big mass tort case.
I think that was the 3M earplug case. Based on my reading, it was like 200,000 cases that got shifted to Northern District of Florida. Does that sound about right?
Yeah. So just to wrap up before I take the deck down and we have more of a roundtable discussion, we see this as a good starting point of something that we can keep evergreen, because data is always coming out. It needs to be kept current if you're going to rely on it. The data is already a year old. So when we get the new data and continue to work with Gavalytics, we're going to update this. From our perspective, and both Dan and Andrew and I have had these discussions. This is just a piece of data that you could use ultimately in a bigger picture of what is the value of my case, when am I likely to see recovery if I prevail, and then what are these external factors, trial dates, the likelihood it'll get moved. What about another Omicron or another event that sends everybody, back to their, homes because they can't put people in seats in a courthouse. ultimately leads to, okay, the real value of my case today is X, time over money is Y, and that in combination would give somebody the ability to say, I don't want to do this anymore. I want to settle, it's time to go, or I do, now I want to do it, or I want to file, I want to try to move the case, I want to get to a better venue. So I'm going to stop sharing, and Kyle, I'm going to let you take.
Yeah, sure. We have a question from my good friend Tom Herney in the chat feature, and it's one that came to mind for me too, and that is, what do you think is the reason for the uptick in filings in the Fourth Circuit versus the Fifth Circuit? Did the plaintiffs see the Fourth Circuit as being more favorable? I think one of the things I heard you say is you have to account for the 3M, which fell within the Fourth Circuit, the MDL filings, but is there some reason why the Fourth Circuit data in terms of filings was so significantly different than the Fifth Circuit?
I think the 3M, Rich, I'll jump in real quick. I think the 3M MDL is in Northern District of Florida, so that would have been I don't know that would play into it. Rich, I don't know if you have hypotheses. I'll let you jump in, and then I can.
Well, I can tell you that it's the volume is typically tied to things like tort cases, medical malpractice. It's not antitrust cases. We didn't see a whole bunch of new antitrust work or patent litigation being filed in the Fourth Circuit. It's the stuff that is already volume centric, and what we don't know is what caused the delays. Right inside the court system, we don't know what judges or what was happening, internally, where they said, "Look, we're going to have to postpone all this stuff for 30 days and then 60 or 90." So it's hard for us with the data we have to pinpoint exactly what the reasons are. We could tell you by the types of cases, it's more likely ERISA, it's more likely, malpractice stuff than it is, big commercial cases.
Yeah, I think when we were visiting before, one of the things that struck me was the significant difference between the Fourth and the Fifth Circuit, especially when it comes to basically the number of cases that were ended during the COVID crisis. And that's really, from my perspective in the Texas, the Fifth Circuit, I think that probably is indicative of the choices that a fine, talented group of plaintiff and defense lawyers made in light of the COVID pandemic for their cases to reach resolution and reach a reasonable resolution during that time of great uncertainty. And I would, but I don't have an answer at least that makes any sense for, why that didn't also happen in, the Fourth Circuit. Which is very interesting. One of the things I wanted to ask about, and this is one of the outside counsel for the defense and inside counsel, corporate counsel, whatever phrase you want to use, a lot of them are judged upon the life cycle of a case. In other words, that's one of the key performance indicators for that group of people. Are these cases remaining on my docket for an extended period of time? Because the longer they remain on my docket or remain in my cachet of cases, the more expensive they become, because there's other things that can or may be done. So it makes me wonder, okay, I'm outside counsel, I'm corporate counsel. How do I talk to my management or my people about and use this data to say, look, I understand they're staying longer. But here's what the data shows. It's really not, there's nothing I can do about it because there's such a backlog out there. Y'all got any thoughts on that? And Andrew, this may goes right to your, sort of your bailiwick. You're looking for return on the investment, and you've got people that you've given the money to, and you have to be or you've loaned the money to, that you have to be somewhat understanding of. If I'm loaning it in the Fourth Circuit, I may have a longer life cycle. So those are two questions.
Yeah, I think that's right. And I can jump in on the first one. I think maybe this data is useful when in-house counsel that, sort of that on the defense side particularly is talking to their board, as you say, hey, look, it's not just sort of that our cases are lingering longer. This is going on all over the country. I think as we mentioned before, and as Dan alluded to, it can also be it can be a strategic point. You know, do you file that venue motion? To go back to the title that Rich and Carl came up with for the article, and then for the panel this afternoon, is do I stay or do I go? You know, what's your strategy? Do you want to move this around to somewhere that's going to drag it out and you can bleed the plaintiff a little bit? That could be a strategy. Or you know, on the other hand, if your goal is to get this get things resolved quicker, because that will cost you and your client less money, you know, maybe you don't go, or vice versa. And Kyle, as you alluded to, this data is very useful, or potentially useful for us. But I think what I'll say is more data is always useful when you're trying to value the case, when you're trying to figure out, how long is our investment going to, what's the life of our investment? That's, in the same way that, you say that some in-house folks are judged on that, but certainly we are too, whether formally or by our investors. And so I think the way that we would use this data is around the edges. We're still going to rely on the experience of our attorney team, myself and the others that are on the attorney team, in the first instance, to figure out, is this a good case? Because that's always going to be what drives the settlement value, or the value after trial. But it absolutely matters if this is going to be a 2-year commitment versus a 4-year commitment, and so that can make a huge impact on the bottom line and returns.
I want to add something here, and I want to ask Dan to jump in. What I've seen from Gavalytics, and I know that there are other people doing this as well, is your ability to get granular down to the judge. Like, you guys can give predictive analytics on a specific judge and how they'll rule on a motion for summary judgment, and how they've ruled in the past by type of case. Do you want to talk about that for a second?
Yeah, I mean, we've gone extremely deep on this point. So it's not just by judge, we do by law firm, in some cases by specific lawyers, by litigants with judges, every permutation thereof. And not only that, but also the kind of things that happen in a case. If there has been a summary judgment which has been denied by this judge, can we see that the case happens to go a shorter period of time? If somebody's filing for motion for summary judgment, they think they've got a very good chance. Could that mean that they go for trial more often, don't settle, it goes longer? Or does it go shorter because it's an easier case? There are just so many kind of data points that we have. It's ripe for regressions, but at this point, what we do is provide that information. We don't have the answers. We have what's in the dockets and how they're aggregated at a very kind of minute level.
Yeah, and I think that's, to Andrew's point about working the edges, right? The more data and the more analytics that are available to trial lawyers, Kyle, is really, helpful in determining strategy and knowing, hey, if we file this motion, this is what's likely to happen. And if this happens, here's what our plans will be going forward.
Mm-hmm. Yeah, and Dan, I was going to address the Dallas data that was put up, because y'all have access to the Dallas County data, and it looks to me like that there were filings and there were not as many terminations in Dallas, maybe compared to other areas in the state of Texas. And certainly, as you're a plaintiff's lawyer and you're contemplating, do I file in Dallas? And if I want to press the pace, if I want to press it to the point where I get a trial setting within 13 months, you could look at this data and you could say, that's really not going to happen in Dallas County. What are my alternative venues that are good and acceptable and good for me that I might be able to file in, as opposed to getting behind the backlog in Dallas? And then I looked over and I saw the LA data. I mean, and really, you're not sitting behind criminal cases in Dallas, because there's a criminal court system where criminal cases are handled by the criminal courts and civil cases are handled by the civil courts in Dallas. So Civil cases, there's a backlog in Dallas right now based upon that data. And that has to enter into my decision-making process on whether or not I really file in Dallas or if I can file somewhere else. When I go over to LA and having practiced law in California, at least as a friend of the court, having done that and been in LA, it's always been a longer time in California in civil state court than it is perhaps anywhere in the country. And now I look at the data and I say, it's even longer than it was before. The chances of me getting to trial in LA County or wherever it is that's right there with the city is just, it's de minimis. And that's got to impact the financing. It's got to impact the planning and all of that kind of thing if I can't get out of that county. That's the way
if you were a defense lawyer, wouldn't you try to move from something filed in Orange County?
I think that's, I think there's different strategies that defendants have. And, in today's world, I think there is an emphasis on, reducing the overall legal spend for defendants and plaintiffs alike to make it more cost effective and cost efficient. And certainly I would look at it from a defense perspective. If that's one of the target goals of the client that I have, I might be reticent to want to go and sit in California for 3 or 4 years. In LA, I may be wanting to push the pace as well to try to see if we can come to resolution. And I may be looking for opportunities to engage with the plaintiff about a different venue that's acceptable to them and to my client. I think those are the kinds of decision making that people will face, whether you're on the plaintiff or defense. That's just my, overall thinking.
I mean, there is.
Go ahead, Dan.
So there is a small risk of taking many, many different factors, aggregating them together and finding one trend which isn't perhaps the underlying one. So it could. So I know, even take away the COVID thing, you look back, LA County has longer times than most parts of California and pretty much all parts of the rest of the country. New York is extremely efficient. California, perhaps not in this regard. But I know that there are certain case types for which LA is actually pretty good. I'd say LA is pretty good relative to the rest of California as well. So I think you kind of have to dig deep. And if you file a case and you are assigned to a given judge, you can say to that client, this judge is quick, this judge is slow on this kind of case. If you just go on this county is like this county is like that,
right,
there's real chance that you could be losing out on something, a clever move, as it were.
That goes right along with what I was going to suggest, and I'll talk a little bit about the way that we would diligence a case here. And as I said, one of the sort of best things about Long Free Capital is the smart people that I get to work with that have been litigating these cases all over the country. Everybody sort of had a nationwide practice. So if you're a litigant, you're talking to us, you're going to get the benefit of our experience as sort of unbiased eyes coming in and looking at your case and being able to pull in all these from all these different sources. What we also do is we hire outside counsel, and whether it's through once we have sort of terms in place, we hire outside counsel to come behind us. And what we do there is we try to hire subject matter experts that know the court, that know the judge, that know the type of case. The reason I mentioned that is Kyle, when you were talking about, do you want to go somewhere? Dan suggesting that maybe it's not that bad, depending on the judge, but depending on the type of case. One thing that I'm absolutely going to do going forward is, if we have a case that we like that's in one of these districts that at least nominally is taking a long time, I'm going to pick up the phone and talk to somebody that is there, that's on the ground. I'm going to, for something in Dallas, I'm going to talk to somebody in Dallas and see, hey, what's the story? Is it really this bad, or is there some outlier reason, that the data didn't pick up when we were talking about it before, such as the 3M case in the Northern District of Florida? The answer may be, that it's just fine, and we're going as quickly as we ever have, particularly if you have, Judge Jones.
Right. Interesting. Well, the data from a federal court system is obviously, you can get data from Lex Machina, who does a lot of the same stuff. In Gavalytics, you've got data on a number of different, state courts. And I didn't mean to paint with this broader brush, but if generally overall speaking, I've got a shorter time versus a longer time, then I have strategic decision making that I need to go through. And that may lead me to a more granular level, the deeper level that Gavalytics and Lex Machina go to for specific judges, for specific cases, for specific issues. So I think that's something that every trial lawyer needs to consider. Where do you think the data goes next, Rich? I mean, what do you anticipate? Do you have any expectation for what the Omicron situation is going to do? Do you have any expectation there's going to see something different when you analyze the data, for 2021?
I don't want to prejudice or have Carl, kick me in the shins after this is over by saying you shouldn't have said that.
Yeah, I understand.
But it seems obvious for now, at least now, that it's going to create some delay. Right, the 2021 is going to start looking better and better as we get, until we get to the end of the year, and for at least the, beginning part of 2022, things are back to, having slowed down some. So, I think we should see an improvement on the numbers, but I could be wrong. The data is the data. For 2021, a slight improvement. And one thing that we should point out is that courts themselves know this. They might not have all the data points that we're giving them, but they inherently know they have a problem going forward, that people can't come to the courthouse like they used to for all kinds of reasons. And so, you can see this. Michigan has a really neat program where they've decided that courts should be a service. And so they're doing alternative dispute resolution online. And they're rolling stuff out so that people don't have to come to court to engage with the court. So I think that some of the hybrid things that we're seeing over time are going to make this less of an issue, because right now you still can't reliably put jurors in a jury box and say, let's have a trial, right? Because Omicron has certainly put a damper on that. Carl, do you want to talk a little bit about the granularity of the data and how we might be addressing, getting better, more accurate results?
Yeah, I wanted to talk a little bit also about like the technology aspect of it. So I think it'll be very interesting to see which districts and for which types of cases and everything like that, were people able to adapt to the changes of COVID. COVID, it wasn't over in 6 months. It wasn't over in a year. It's still, going on. So how did they adapt? How did the courts adapt, and being able to see and maybe draw conclusions from that, yeah, maybe, Michigan's district, maybe their numbers are going to look a lot better because they were able to implement these new technologies and made new, changes to how they were doing things to address these ongoing issues. So I think that'll be a fun trend that we can kind of pull out from this, and it'll actually, teach us something about the court systems, and maybe other courts can see that and maybe start adopting these other technologies. But onto the granularity and looking more into getting more accurate results. There's a lot of data out there, and I mean, Gavalytics, you guys know it. There's a lot of data out there, and so going forward, we want to make this better. I think there's a lot of things we can do. There is more historical data that that the US Govs has. It's just all in PDF, so we have to clean it and organize it that way. And that'll, I think, give us better long-term trends. Even some of the fits that we had, maybe the linear fit wasn't perfect. So looking back at more data, we might be able to have better trends going forward. And then having more than 1 year of, this expectation, rather than just saying, oh, it dropped off by 1 point. Maybe it's going to be, maybe it's not a linear decrease, or it's not a linear increase. Maybe it's going to start showing exponential trends of, there's a huge backlog here and it's just growing and it's growing and it's growing. And it's, going to end up, when we predict out that at the current pace, this will be 5 years before, cases are being seen. So it might be an early indicator of, something much worse happening if, a specific district didn't show improvements over the last year. So having more data is always better. We can always draw more conclusions from it, but it's hard to get those long-term predictions without enough data points.
It would be very, very interesting to see if the difference between different parts of America's COVID policies kind of relates to this. I mean, there are, several numerical indicators for how closed or how open an economy is, from, your Florida extremely open to your, I believe, Massachusetts very closed. One would think that, as a data point, that would kind of determine the strength of the effect of, COVID there, and especially in state courts, of course, but also, at the federal level. Like, having that as a kind of non-linear point or an additional factor would be a really cool data point to look at.
And my gut instinct is that it may very well. Living in Texas, and I told you guys the other day that I don't know that Collin County in the state of Texas is far behind at all. In fact, they may have both fewer filings and more terminations that have happened because they have proceeded in some respects in a different fashion, and their reaction and treatment of the COVID virus is different than it would be in some other locations. And I think that would be interesting data. I had a question that came up, and maybe it's expanding it, but with all the talk of analytics and surveys, do you think analytics will get to the point where, in addition to sort of seeing predict what the judges are going to do to predict jury verdicts, do you think we'll have enough analytics available through the federal systems and through Gavalytics and other organizations to be able to more reliably predict verdicts?
Well, it would certainly help the show bull.
I mean, I'd say at the state level, my first inclination is, if there exists data, there will be at some point a computer smart enough to read it. And then once a computer can read it can read all of it, and we can draw conclusions thereof. The only issue when it comes to jury verdicts is the volume. I mean, as far as I'm aware, the entirety of California had, 1,200 jury verdicts a couple of years ago in a single year. It's the statistical significance you get off that from just a kind of opening point wouldn't give you enough confidence to make decisions. And that's kind of a really important point with all of this. We need enough scale to make decisions. If you have 5 cases and they're all much longer than they were before, you can't make a conclusion off that. 5 cases means absolutely nothing. You need to get the volume so that your variance is low, so that you can say this is a statistically significant difference. I mean, I would love to get my hands on every single jury verdict and do some NLP and see if there is something in there. And there probably will be some trends you can really get, but I would be very skeptical on whether those conclusions could be trusted until there's just so much more of it. And
that's a great point. When we looked at the federal statistics, I think it was 1,000 cases. When we say there's a 47% increase, that means there's going to be 1,500 cases. And so, there isn't a lot of data. And I think the question included a reference to whether this would replace mock trials, and the answer is clearly no. But getting more analytics that are useful is going to be helpful, and it leads to something kind of related, which is, when and how soon will we see people like Carl taking the witness stand and testifying to some of this stuff, right? And we've published a few things about expert witnesses and the work that data science people are doing behind it. And we see a future pretty rapidly where you're going to see dueling data scientists, trying to explain to a court and to a jury, here are the analytics, here's the artificial intelligence involved in this claim. And so explaining analytics to a jury is going to become ever more important.
But I would add to that, I agree that I don't think it's going to replace a mock trial, because as any trial lawyer worth their salt will tell you, how you present something is just as important as what it is you present. But I could see, Rich, it'd be interesting to get your thoughts on this. I know that you've done sort of the analysis of the public filings of companies, right, in the past to predict, are there keywords, hot words, the type of language that's used that's going to predict whatever it is, an adverse outcome or a positive outcome. Yeah. I could see a time where trial lawyers would be able to, particularly in cases where they're where there are enough, or types of cases where there's enough data to be useful, as you guys said, upload your closing statement into the machine and let it tell you, we don't like the word, stole my client's wages. We like, something different. And I wonder if something along those lines is not too far afield, and it could be, a tool. As you say. I don't think it's going to replace anything right now, but language matters, I think, in jury trials, obviously, and that could be something that
as a purely a fun thing, this wasn't something we ever sold. We looked into rulings by judges, and we ran sentiment analysis over it to see what kind, and sentence structure to see how they kind of write, with the expectation that a judge will want to see something which is written similar to how they write. And we found there are large variations. Some people use emotive verbs. Some people are very straight to the point. And that, it's not something we're ever going to sell because I don't have the significance on it, but it's a really kind of interesting data point. But coming to your point of can you take an opening statement and decide what's going on? You can look at things like complaints, where you can access a lot of them, and see when this case is cited along with this case, your probability of winning, especially if it's a motion where the data is far more available, is X or Y% higher or lower. And then you can be selecting which cases you're going to fund if they've got to complaint stage by, I like the ones which mention this, this, and this because they finish quickly and I, get paid. There's just such a world of data out there. It's really, the only limit is how creative you want to be.
You bring up a great point. We did our own fun study, something similar. We took all the Supreme Court cases that involve securities class actions, and we went to see if we could build a model that would predict the settlement time and value of a securities case based only on the complaint. And we were able to do that. Pretty big variance of high end, low end, and it didn't include things like motions filed during the case. It was just purely, here's the complaint, what's the case worth? And that's coming, right? So for guys like Andrew, that's a big plus. Here's the complaint, what's it worth? I also think that prediction of future types of cases is going to be very helpful to everyone. We've been doing some work on ESG, and when the SEC makes the reporting mandatory, we foresee shareholder litigation because right now you say what makes you look best. We are going to be carbon neutral by 2030, and when it gets to, you got to report it correctly, and all of a sudden there's memos from inside the company, people going, what did this guy say? We're not going to be carbon neutral ever. We do foresee future shareholder litigation over ESG, and that's just one example.
Yeah, I find it interesting your comments about the predictability of jury verdicts are well taken, and they're well taken in the sense that there are so many other variables beyond the day that the case is filed and the day the case is ended, regardless of case type. There are so many other variables, including the talent and proficiency of the lawyers from both sides, the talent of the witnesses and their credibility, and a whole host of other, not to mention the fact that you have to have sort of similar type cases, enough similar to be able to draw some conclusion. And if you're only trying 1,200, you're not ever going to get to the enough similar type cases to have any sort of statistical significance in it. I'm going to give you all an opportunity, each of you, given the data that we have and the kind of thoughts that we've been discussing, some final thoughts, because I promised that we're going to be done by the 1 o'clock hour. So any final thoughts about the data?
I'll start. What we think will happen is that, much like when you see a sport, a game being played, and they have a slider. Now they're 58% likely to win. Now it's 63. Now the other side, that the granularity of this information is going to give people a better understanding of what the value of their case is over time, and allow people to make more informed decisions. We actually think there should be more settlements that come out of that, because people can get more realistic information and go, hey, I just lost these 3 motions. My chance of getting recovery has just gone down to X, and the recovery's gone down to Y. I'm going to take my chips and go home. So we think that this becomes something that, like all the analytics you see in business and in sports, is just going to become part of the, culture of how this works.
Yeah, and kind of piggybacking on that, because I think it's a fantastic point, that the world's not very far away. When the data is available, this isn't mathematics which is beyond us in any way. It's just availability of the data. In the federal world, that data is pretty available. Would it take a long time to be producing that sort of metric in a very kind of understandable and reliable way? Absolutely not. At the state level, it really is just an example. Well, it's the kind of thing which would improve the functioning of the market, reduce how many trials you have, increase settlements, which is what people want. I don't want to be paying, a judge to be ruling on something nothing to do with me. It's a cost. Really, the way that state court data is so inaccessible is therefore an economic drag on the efficiency of the market. So it'd be good if this kind of trend in the federal space would create more openness and more integration and less granularity in the state space, he says, noting his entire business is based on that.
You said it. Yeah, I gotcha. That's good.
I'll add simply that I'm excited to see what my fellow panelists are going to come up with in the coming months and years. I think it absolutely is true that this is going to become more and more valuable. Although, Rich, I'll say, the predictor, the slider, it reminded me of the Bills Chiefs game on Sunday night. We would have bet with 13 seconds left at the game. So there's always going to be, at least in my opinion, room for interrogating the data. But it is exciting as a piece of the analysis, whether you're sitting in my position or you're a litigant or you're an attorney advising your client. I'm excited to see where it goes.
Yeah,
I will add to that. You never know when somebody's going to snatch defeat from the jaws of victory or how that happens. So a judge can do that with a JNOV, and you thought you had everything going. So
I mean, absolutely. It's like, Tyson said, everybody has a plan until you get punched in the face. Like every prediction I would have made in late 2019 did not come to pass. It's like economic predictions. It's never going to, we're not prophets. We're not telling the future. We're telling you the probability. And we like to give you certainty because that's how people work. It's never actually divining the future. It's saying what should happen, assuming everything stays as it was. Will COVID create structural changes which are statistically significant going forwards? Would love to see it. Good for my business. It'll be something I can find, but maybe it won't. I don't know. And I think that's kind of the essence of it, is I don't know, and no one does.
Guys, I want to thank y'all. It's been great. Rich, Carl, Andrew, Dan, I greatly appreciate y'all jumping on. I find this stuff to be very fascinating and interesting in terms of our ability to, whether you're plaintiff or defense, manage litigation on a moving forward basis. And we look forward to having you back in the future when there's newer data and to talk more.
We'll be back.
The way
you'll have us, we'll come back.
Yeah, the way data is being used. There should be in the chat feature. I'm hoping that we'll have the CLE credit that'll be posted there for you. And again, thank y'all for joining us for this great discussion. I apologize. The pool guy, I now know what Zoom is like, right? The pool guy rings my doorbell. The dogs go nuts in the middle of y'all talking. And so if I turned around and looked like I was hollering at somebody, it was the pool guy. So I apologize for that and really do appreciate you. Thank you so much. And we look forward to all of the rest of you joining us next month for our next Baylor Law Executive LLM and Litigation Management webinar. If you got an interest in the program, go to the website for the Baylor LLM program. I think it's llm.baylor.edu. We'd love to answer any questions you have about the program and what we do. These people that are on this call right now are all actively involved in our education of JD graduates in our LLM in litigation management. And we thank them for their active engagement and working with us in that program as well. Thanks all, and everybody have a great day. See you later.
But,
Thank you.